to start on the side of the defendant's constitutional rights. Now, of course, the court has to balance many different things. One is, what is the coverage of these particular cases and their related matters been like past, present, and future, if you can get a good idea of that. Well, Judge, I think in our objection, and you probably may already know this, it's quite clear that the coverage on this has been excessive, widespread, consistently negative towards Lori, and I'll just throw out, I know I'm missing lots, but there's a Netflix docuseries, Dateline programs, 2020, constant national and local coverage of this case of the sort you do not see in other cases. There are articles about Lori made a couple jail calls. That's headline news, apparently. The commentary sections on these things, they're always negative. It's always, especially if it's a visual situation where it's a photo or a video of Lori in court, it's just maligning her, vilifying her for people in our jury pool to see. And what they learn from that information is she is of such a terrible, evil character that she's not even entitled to her constitutional rights. Typical things we see in the things I've cited for you. Again, Judge, it's enduring, consistently prejudicial, often undignified, and it's widespread and clearly impacts this jury pool in this county. Judge, I believe the court has to conclude Lori's right to a fair trial in these two cases is in jeopardy. It has been, it is today, and it will be in the future without intervention from the court of some sort regarding the excessive media coverage. Judge, you've heard no argument that actually supports why this relatively inconsequential hearing at 8:20 a.m. needs to be live streamed or video recorded or new images produced for the public to see. I don't know the state's position. Of course, they are entitled to let you know that. But thus far, there's really no good reason for it. Rule 9.3b1 does make clear court hearings are open to the public. That includes media representatives. We're not asking at this time for the public to be banned from this hearing or any in the future, or the media to be banned. We are just asking for a specific limited request for this 8:20 a.m. hearing for there to be no camera coverage of the hearing. And Judge, I do ask you to provide, if you're going to allow the camera coverage in your ruling, addressing the Rule 122 factors. I've already addressed most of those. A few new things, Judge, just to add, I don't recall if I did in the objection. 122C, the safety and well-being of any party. Lori has received death threats since her arrest. And additionally, Judge, 122G, I did not know the news entity that made the request, but now that I do, clearly Fox 10 Phoenix is, well, it's not a person, but it's someone requested engaged in dissemination of news to a broad community. All the Rule 122 factors point in the direction that this should not have camera coverage, this particular hearing. Judge, I have other things I want to address, but it's only if the coverage is going to be allowed. So I'm not sure your inclination. Should I continue? Or if you would give me a chance then, if that is your ruling, to then further address the court.
All right, let me hear, does the state have a position or the victim representative have a position?
Your Honor, just the state is aware the media and public do have certain rights, but for this specific hearing, the state is going to take no position at this time.
All right. I guess Fox 10 News has a representative here that's the real party in interest that made the request. Is there any statement that Fox 10 wants to make?
Yes, Your Honor.
Come forward. And your name, sir?
Justin Lum.
You already told me that.
Yeah. Your Honor, I believe the defense's motion argued that there's been oversaturated coverage of this case, but I would argue that it's been extensive and thorough coverage of Ms. Vallow's case since December of 2019. At the core of this, and I'm sure you're aware, that there is a case in Idaho that was tried and she's been convicted there. So all we have done is cover her crime she's committed in that state and the crime she's accused of here. Due to public records requests, we have been able to obtain police reports, body camera footage, videos, interviews from Chandler and Gilbert police. Much of this evidence has been seen in her trial in Idaho and will probably be seen in this upcoming trial. That is all we've focused on as far as the case. It's a high-profile case with a lot of interest, and we believe that covering this hearing is just another development in keeping people aware. As you know, there are victims in the courtroom right now, or family members representing the two alleged victims in this case, but there are also people who do not live in this state and want to be aware of what's happening. And if you have seen the recordings from the court when there is not a broadcast camera inside, you can see that the quality is low. Now, that may not be a priority, but we just ask that you allow cameras for this hearing so we can keep on covering this case as best as we can. Again, the argument about the issue of finding a fair and impartial jury, I would say that Maricopa County has 4.5 million people in population size. It's the fourth largest county in the country. There was no issue finding a jury in Idaho for 2 trials, including Ms. Vallow's husband, Chad Daybell. Ada County has about 500,000 people. If people want to know about this case, they can go on the internet. I don't think Fox 10 Phoenix or any other media outlet here should be blamed or punished because we've covered a high-profile case that involves 3 murders in Idaho and 1 alleged murder here, an attempted murder in this county. Thank you.
All right, thank you. Mr. Bradley.
Judge, I do need to address some of that.
That's fine. One of the questions I have for you is, if I weren't to allow cameras in the courtroom, obviously the quality of the camera coverage is not my concern. I don't really care. But my question is, anyone can go order an FTR of today's hearing and obtain what happened, video of what happened, audio of what happened here in the courtroom, and then disseminate that however they wish. So I guess what's the additional harm of allowing a camera in the courtroom?
Well, Judge, that is not something I agree with, and I filed a motion to that effect a while ago asking the court to order that FTR and court recordings are under the umbrella of Rule 122. I can make a really brief argument about that, Judge. Rule 22 is very general. It says if the media wants to use quote-unquote recording devices in their coverage, they have to let the court know, then the defense has to be told, and we get a chance to object. And if there is an objection, there's a hearing. For the court to deny their own cameras in the court today for good reason, and then for the media to just 15 minutes after the court hearing grab the court's hearing and just broadcast it, what would be the point of Arizona Supreme Court Rule 122? It would be rendered completely superfluous. Any decision you make is based on, at least partly, Lori's constitutional rights, possibly fully. And I don't know, at some point, why would Fox not even ask for their camera? They can just grab the FTR. Rule 122 has to apply to judge your court cameras as well. It just doesn't make any sense that it wouldn't. And that's essentially the argument I have to make on that. And we filed a motion on that issue. I would like to respond very briefly to what Mr. Lum said, though, because I think there's a lot of inaccuracies there.
Go ahead.
Judge, Mr. Lum told you that in Idaho there was no issue with seating a jury for Lori's trial there. That's absolutely not true. There were such issues with the media coverage there that a change of venue motion was granted in Idaho, which is rarely ever done. So that's absolutely incorrect. Mr. Lum's probably correct on his general population numbers for the Maricopa County area. But, Judge, this coverage is extremely widespread. I'll give you an example. And I think this is cited in the objection. It's called No Remorse, the trial of Lori Vallow. The very title has prejudicial information you would never allow your jurors to hear before they were seated in these cases. That, apparently, according at least to the YouTube summary, was April of 2024 that was put out, and it has 87,000 views the last time I looked, which was, I think, yesterday. So this isn't a situation where Mr. Lum putting things out there is getting 12 people watching, which is sometimes the case with high-profile cases. Judge, I disagree. I totally agree with Mr. Lum. This has been very extensive coverage, but it hasn't been thorough. You will have a hard time finding anything that's balanced coverage in any of these cases that even suggests that there's something different than the obvious narrative that goes through when it comes to Lori Vallow. And Judge, Mr. Lum's actually proving my point. He just told you that he and other media representatives are obtaining evidence that the state, we know, is going to produce in court for our jury, and he's putting it out there in the public. He's correct. He's put body cameras, he's put police interviews, all kinds of evidence in this case the media is putting out there for the public to consume, including lots of people we can assume in our jury pool. And as he said, he's constantly mentioning not just him, it's really everybody that's in the media, but her prior convictions are always mentioned, often with links to other prejudicial articles. These are things I think the court has to ask, is this information that I would want my jury to know before we start jury selection? Would I tell them that? We all know, Judge, you wouldn't. So I don't think anything Mr. Lum said should be given much weight by the court. And he absolutely addressed nothing about any measures they might take to even try to protect Lori's constitutional rights. Now, they don't have to do that, but those are my thoughts on that, Judge. So, again, I can stop here. I just ask that if you're going to allow the cameras, either through FTR or their own cameras, I do ask to be heard just with some additional requests.
Go ahead.
Okay, Judge, if we are going to allow Lori to be filmed today or photographed, I do ask that she dress out. I don't think she should be compelled to wear jail attire going forward in these hearings. I think the U.S. Supreme Court case law I cited is clear that courts can't compel defendants to wear jail attire. Although there is a little bit of a distinction, Judge, those are cases in trial.
Correct.
But I don't think this is any different. I think this is actually worse. This is not as important as a trial. So, Judge, I would ask first for that to happen. If that is not going to be allowed, I would then ask the media not be allowed to film Lori during the hearing. They can film Your Honor, they can film me, they can film the state, but not to film her. We know it's going to happen if they do, and I can promise you when you look at the commentary tomorrow or the next day, it's just going to be vilification, maligning of Lori, causing more prejudicial information to come into our jury pool that will continue to taint it, and it will be due to the visual coverage. If, Judge, you're not willing to do that, I would ask that we briefly have Lori put her position on the motion to continue trial unrecorded in front of Your Honor, and then ask that she waive her appearance after that. I'll have to talk to my client, but a last option would be if the court's going to do none of those things to help protect her rights, we may ask to waive her appearance completely for the rest of the hearing. So I know that's a lot. Let me know if you have any questions about anything specifically, but those would be our requests if you are going to allow camera coverage, whether that's through your own cameras or the media.
All right. Well, if you are telling me to not allow anyone to, or specifically the media, to request an FTR, that's essentially you're asking me to seal the FTR recording.
Judge, I disagree with that interpretation, but if that is the court's interpretation, which is more important than mine, then that's what I'm asking. But
wouldn't you agree that things that are filed for the public in the docket and the FTR are generally accessible by the general public? By restricting that from a specific, I can't just specifically restrict a specific entity or person from accessing those public documents or records. So I think I would have to seal something.
Judge, I'm fine if you want to do that, although I do disagree. I think you absolutely can do all those things, and that's provided for in Rule 9.3b of the Arizona Rules of Criminal Procedure, and it's specifically provided for in Rule 122. It's actually a remedy, and I think it's 122b.
Your interpretation of 122 as it pertains to the FTR, but
okay, Judge. So
that's not their recording as contemplated in the rule.
Well, and I also think there's a big difference between something that's filed in the public docket and a video video footage from a hearing. I think there's a great distinction there.
Well, the FTR is the official record of the proceedings. I don't know the administrative order that created that, but it is considered the official record.
And I understand that, Judge, but it's still, I think we're completely ignoring all the case law, all the rules by the Supreme Court and the Arizona Rules of Criminal Procedure, and just simply saying, well, it's a record and it's public, so kind of who cares about all these constitutional rights and the case law and the authority? I don't know that I have much to say about that.
All right. So for the purposes of this hearing, the court finds that the arguments that you've made, really most of the arguments talk about the negative aspect of the stories, the negative aspects of what's portrayed in the media and how that impacts the jury pool. And it does, and it will continue to impact the jury pool regardless of whether a camera is allowed today. And those issues are not insurmountable through the voir dire process in selecting a jury. It does make it obviously more difficult to pick a jury, and it will probably take likely a long time in this case to weed out those jurors that have been exposed to this case in the media, but it's not insurmountable. I am inclined to allow cameras in the courtroom with specific restrictions not to record any victim representative. Do you want to talk to your client about waiving her presence before that hearing?
Judge, as far as the option of her briefly letting her position be known off camera and then waiving, are you okay with that?
Yeah.
Okay. Yes, Judge, we are going to go with that option. A brief statement about her position on the motion to continue trial.
Well, based on your motion to continue, my understanding is you put in your motion that she objects to a continuance, does not want to waive time, correct?
That's correct.
All right. And do you want me to ask her that? Or
Judge, I wasn't sure if you did, so that's why I made that offer, but obviously that's up to the court.
Well, does she want to state further than that? I'm aware of her position.
Judge, I don't think so. I'll just let you know, yes, that position remains, and it has been that position since I've met her, and she continues to object to the continuance that we are asking for today and will not waive her speedy trial rights.
All right. Ms. Vallow, do you want to waive your appearance for the rest of this hearing this morning that will commence in a few minutes? And you understand that your attorneys are asking for a continuance. I understand that you don't want a continuance and that you don't want to waive any further time. All right. I'll waive her appearance for the rest of today. We'll commence that hearing in about 5 minutes. The media may set up a camera if it so chooses, but Ms. Vallow is free to be returned to the jail.
Thank you, Judge.